Swandaga, one of the actresses in this country, to the Minister of Arts and Culture, which unpacked all sorts of grievances. And since then, a lot of other things have happened. People have had discussions. They've been on other platforms as well discussing the issues. But I think what we haven't done is to unpack what's at the heart of the problems that the artists are facing. Artists have always been complaining about issues in the industry. It's not the first time. You remember when the Generations cast was fired, and it's been in public spaces and in private spaces as well. But something else is different this time around. There is a bill that's sitting in front of the president, that's on the president's desk, and the big question is, what's happened to that bill? What's the content of that bill? And how is that bill relevant to what's happening now? That's the major difference between all the other times when artists have raised issues and now. The difference is that this time there is a bill in front of all of us, which changes everything. And it's up to all of us to understand what that bill is about. It's up to all of us to either buy into the bill or not buy into the bill. But we can't do that if we don't understand the bill. So today's broadcast is essentially to really go into the bill itself, unpack something that we all need to understand further so that we know from a position of knowledge what it is that we are arguing for. So I've got a whole panel here with us, and then people will keep trickling in as the day goes by. But essentially, I've got a panel of people who are lawmakers, or who every single one of them has said, no, I'm not. But so generous of them to say, no, but I'm not such a big deal. But they are. Essentially, these are experts who understand the bill itself. And then I've got industry players as well who are packed in here. And I've also got other lobby groups, organizations that represent artists and so on. So you are also welcome to give us a call as well to add your voice. If you couldn't be here, you're more than welcome to be a part of this conversation on 0891 104 207. Welcome back, and we begin our conversation around the bill that we've been discussing for weeks now on end. And I think many people who are sitting at home have been asking themselves, we're not artists, what are these people talking about? In fact, there was somebody who on Twitter said, what can we do and how can we support you guys? I mean, we hear you, and essentially we kind of understand that, you're not happy and we want to support you, but how do we support you? So let's begin with unpacking what it is that the issue is. So we've got a bill that I think many of us don't understand. I've got a panel, as I said, and I'm going to get the mics to my panel. And I'm going to start with Nothando Thusi. I see, Nothando, you don't have a mic, so I'm going to get you a mic there quickly because you're quite fundamental to this piece of what we need to discuss. And you from Recreate SA, Coalition of Creators in South Africa, supporters of creators' rights and social justice promotes through the Copyright Amendment Bill. So that's a long title. What are you guys advocating for?
Hi, first of all, I just want to say thank you for having us. So essentially, we advocate for the passing of the bills as they stand, and I think
Both
bills, both the Copyright Amendment Bill and the Performance Protection Amendment Bill. And as an organisation, we have a number of other organisations that fall under our umbrella that also support the same mandate as we do. And I think a conversation that hasn't really been brought to air that much is, what can we do at this stage? I mean, it's all grand to have all of these conversations about the bills and having stakeholders and industry understand the bills and the implications, etc. But the bills are currently sitting on the president's desk. And the question is, what remedies are available when the bills are on the president's desk? And that pretty much is sign the bills, send the bills back to the National Assembly. If the National Assembly doesn't change anything, then he has to approach the Constitutional Court if he feels that he still has issues with the bills. And it's also very important to understand that the only reason that the bills can be sent back to National Assembly or the Constitutional Court can be approached is if the bills are found to have any constitutional issues, and we are of the belief that the bills pass constitutional muster.
Okay, so that's interesting, because one thing, you've done two things. You've unpacked the fact that there are two bills. That's the first thing, right? Because there's this idea that people are fighting about a bill, and yet there are two bills. There's a copyright bill and the performers bill, right, which is two different things. And I want to bring in here Chris Mamatuja, who's a Black Lawyers Association Gauteng Provincial Chair, who also understands this bill. Stephen Hollis is also here, partner at Adams & Adams, and I know that you guys have also looked very closely at the bill. So first and foremost, there are two separate bills dealing with very separate issues. And this is part of why artists don't necessarily always speak in the one voice, because sometimes you have an artist who's a performing artist and dabbles as well as a producer, making things very complicated because the bills are addressing two separate entities. Copyright dealing with the producer, the performing element being the performance bill dealing with the performer. Very different interests, and therefore sometimes you have this noise, which is very different. You also dealt with the fact that the bill is now sitting on the president's table. So correct me if I'm wrong, lawmakers, but that doesn't mean that we are powerless. If the bill is sitting on the president's table, we can lobby to get the bill sent back to Parliament, or insist that if the bill is not going back to Parliament, the president signs it. Am I wrong or am I right? Any one of you, gentlemen?
I think you're right. We assume it's sitting on his desk. It might be in a bottom drawer somewhere.
But it's there. It's in his office somewhere. It's
in his office somewhere, and I think we do need to refer to the bills. Although they look at different issues, they are inextricably linked.
Correct. We'll get there.
You don't want me to go into that just yet?
No. I mean, we've got 2 hours to unpack the entire thing.
All right. I'll speak slowly.
Yeah.
The Performance Protection Amendment Bill, for the first time, gives actors in audiovisual media the right to claim royalties, residual flow of income from their work. However, the ability to collect those royalties is all sitting in the Copyright Amendment Bill.
So, in other words,
formation of collecting societies and the Copyright Tribunal. So,
the thing here is that, unfortunately, the bill speaks to one another. There are elements of the Performers Protection Amendment Bill that refers you back to the Copyright Bill. That's the issue here. So just for clarity.
Yes, because performers' rights to royalties are not copyrights. Correct. They are what are known as neighbouring rights.
Correct.
So they do rely on the mechanisms that are being introduced by the Copyright Amendment Bill in order to be given effect. Mm-hmm. So they're pretty inseparable.
Correct. Okay. Although there are 2 separate bills.
Yes.
No, so obviously for me, I keep doing this because we have an audience that obviously needs to understand where everything sits. There isn't the assumption that everybody understands what's going on. I think we need to bring everybody else along with us. Okay, so you're saying it's maybe somewhere in the bottom drawer at the president's office, but it's there.
That's the impression we seem to be getting because nothing's happening.
Chris, your comment?
Thanks for the opportunity. I think that I think my fellow panelists has already touched on it. But I want us to just focus on the objectives of the bill.
Yes.
of the Performance Protection Amendment Bill.
Let me ask you something fundamental, Chris, because maybe people are also asking, where's the arts and culture people? This is not an arts and culture bill.
That's correct.
Let's start right there. This is not an arts and culture bill. This is a trade and industry bill.
There are mixed debates and views about who owns these bills.
Let's talk the facts. I mean, I think that, our point is just here.
But the current bills, as they sit, are spearheaded by the Department of Trade and Industry.
And that's the question I want to ask you. Why is that? So that people understand why this is in this category.
If you look into Section 2 of the bill, which talks about the objectives of the bill, and I want to quickly just read it for the audience and for everybody to understand.
Take your time.
It says that the bill seeks to address the challenges facing the creative industry for non-payment of royalties. That's number one. Number two, lack of formalization of the creative industry, which exposes it to abuse. Number three, to abuse, to piracy, and also to deal with the rights of performers by making provision for the following: for the protection of performers' moral and economic rights. So that's very important.
Moral and economic rights.
Moral and economic rights. So if you look into the current arrangement, legislative framework, these things are not provided for. So in street language, you will call it a revolutionary kind of piece of legislation, which seeks to address the historical challenges that are faced by performers. Year in and year out, we hear of performers who passes away as paupers, men of straws, whilst these people are famous. But we're going to deal with that as we go on.
In fact, this is exactly what I want to do, is you've just said to me that this is what this bill seeks to address.
Yes.
Now, there was a bill before that, right? There was a Performance Protection Act, which was in 1967. And my question to you then is, what was its job if we're saying this is what this is doing? So that's something that I want you to ponder on. Let's just take a quick break. And we'll also take calls. We'll take calls to all of you who are sitting at home. If you want to be a part of the conversation, you can also send us a tweet or you can send us a WhatsApp note, and you can call us as well on 0891 104 207. Welcome back. We're having an entire conversation around the Performance Protection Amendment Bill, which sits, as someone said, at the bottom drawer of the President's office. Nonetheless, it is there, and we're unpacking its merits, we're unpacking why it's important, we're unpacking all the issues that I think are leading to us really having to unpack and understand further this particular bill. So before we went to the ad break, we were having a conversation about that there was something else. There was an act before this. It was a Performance Protection Act in 1967. What was the purpose of that act? So if we're saying that the purpose of this bill is to remunerate, for the purposes of remunerating artists, if I now ask you, gentlemen, and other ladies who are in the room, what is it that the Performers Protection Act was missing?
Maybe just to conclude that part, I will leave the issues of copyright to my learned colleagues from Pretoria. They are the right people to speak about these things of copyright. But in short, what was missing is that the old regime only provided for rights to the authors, and these are what you call today the producers of the works. So there was no room for performers. If you look into, I'm just trying to summarize, if you look into what the current bill seeks to achieve, it seeks to put the performers in the picture and also accord them some form of rights as well. What the bill is calling them economic rights. So let me just stop there. I am assuming I've simplified.
You want to add, I mean, it's that and the fact that the mediums have changed. I mean,
yes,
fundamentally.
Absolutely, and I think what we need to realize is what you mentioned is that we had an act.
Yeah.
We actually have an act.
It's still there, yes.
So the act is there,
yeah.
And the bill's intention is to update our Performance Protection Act. And some of the main aspects thereof is to improve, to align itself with government's stated policy objectives, not only with respect to the Performance Bill, but also the Copyright Bill, the Copyright Amendment Bill, which is to uplift and enhance the earning capacities and the plights of our artists and our performers who have for way too long been struggling to make a living and to do well from their art. Now the question is, the thing is, the performers have been left out of the picture for way too long. I mean, musicians can also be performers, and we'll get back to the overly broad definition of a performer in the Performers Bill shortly. But I feel for performers because even though musicians have the right to receive additional monies for the use of their recorded performances on sound recordings, when, you know, through needle time, when a musician's song is played, the performer gets a royalty. Now, our actors have been left behind in that sense, and I understand the frustration. We all actually who've read the letter from Ms. Ndara over last weekend to the minister, you know, it struck a chord, and I think we all recognize that in South Africa something needs to be done. Now, the next question is whether this bill, as it is presently worded, will actually live up to its word and actually improve the plight of our actors and performers. That is the question we need to ask.
Let's just deal with some misconceptions, because Renee Williams is here representing the SABC. So if we're saying that the bill or the act, the current act, has never ever recognized the rights of the performer, right? I actually remember getting a contract from the SABC which recognized my right to royalties, actually, believe it or not. That's not to say they were paid, but they're in the contract. Where did that come from? Was it just the goodwill of the SABC?
I think, as I stated last night, between the period 1993 and 1998, when the SABC was going through a transformation phase, it recognized that there were many actors that were not dealt with professionally during the 80s and 90s. And there had to be some kind of equalizing in terms of that. That particular contract that everybody refers to and that is used as a template was actually negotiated with PAWE, which is the Performers Workers Equity, and they belong to COSATU. So its intent was transformation. Its intent was to say that we recognize we had actors in this industry that were being paid 100 Rand a call, and we will see how we can equalize the system. And we introduced the repeat fees, and we introduced royalties. In terms of that, there was some time before it actually got implemented in 1999, 2000, and we do that. As you stated up front, we might be lagging in terms of making the payments, but the obligations is there. We pay royalties to principal actors in drama series.
How do you quantify those royalties?
So royalties in terms of a principal actor in a drama series is a negotiated fee or 2% of net revenue. If a sale is made, the SABC retains maximum of 35% based on costs for getting that sale. The remaining monies are split between the producer, who gets 15%, the writer, who gets 10%, and then the actor. It's either negotiated or 2%. Repeat fees is a different matter.
I've got a lady at the back there, Carlin, who I want to actually pick up on this, because I also know that there were letters that were sent with the intention of the SABC to pay where they had not paid, where they had not honored those monies. They actually were now going out seeking people to say, listen, we know that you haven't been paid, we want to pay you. But, I mean, it was like 2,000 Rand or like 1,000 Rand for like 10 years type of work. Hence I'm asked, how do you quantify it? So I do want Colin to come in there, because at some point we need to be quite factual about what is and what isn't. Your experience of this, Colin, as somebody who represents SALGA and somebody who's an agent of others.
I think the important thing here is the question that you mentioned in terms of what does the bill do now in its current form before the amendment bills come through. And I think the important thing is, yes, the SABC contract has those clauses. The one thing is, how do you collect them? And most people don't even know if they are eligible.
Yeah.
So the process in order to get them from the SABC is laborious.
Yeah.
Only relatively recently has the commercial exploitation part of those contracts actually been honoured. The most important thing also is to realise that those are only contractual relationships. The legislation, as it stands, does not give the rights
and that's what I
to the actors.
That's,
it's only contract that gives the rights.
So that's what I was trying to get to, Renee, to say, you know, fairly or unfairly. I mean, it's easy to throw stones at you. I mean, hey, you know, and maybe the intention was good, but you had very little that you were working with that allowed you to stick to the letter. We can't hold you to it because, you know, nobody else will do anything for us if you don't. So you have the intention, but there is no law that forces you to actually go about and actually pay those royalties.
Okay, so can I just, if we stick factual based,
Yep.
Whether there's a law in place or not in place, the SABC is a public broadcaster and will always see its role in trying to balance or create some kind of transformation within what it can do. We are not a collecting agency.
Yeah.
We are not a collecting society. When we pay out royalties, we pay out for productions done in 1975, 1976. Those actors have long passed. We have their great-grandchildren coming to us. We've got to process documentation. We've got to look for it. That kind of process is thrown on to the SABC, and it does take long because we do have a lot of rules in place for anybody who works with the SABC. What I'd like to state is the amendment bill, as much as it tries to bring up and adjust some of the previous bill in terms of understanding what fixation means in a new environment, etc., we're still not addressing the big issue about the environment and the economic sustainability and viability of the environment. Who is collecting, how is collecting, those kind of things. When you introduce a bill to change an economic society, there has to be a background to it. You need to know how it's going to be implemented and how it's going to work. That's the first issue. The second issue that we asked for is that there is alignment between the Copyright Amendment Bill and the Performance Protection Amendment Bill.
I'm going to pause you there because, as you know, we've got to do the news, and you of all people should understand that, Renee Williams. It's 1:30. Let's go Kanyisile Manyoni now for the latest in headlines. We're back with our special broadcast, and we're broadcasting live from the SABC Radio Park, and we've got some guests here. We've got a panel full of experts, and we've also got the SABC and other stakeholders as well. And what are we discussing? We're discussing bills that have been of paramount importance to artists in this country, and it's the word artist is a very big word, because it encompasses so many different interests, and perhaps therein lies the problem. So, Stephen, just help us unpack where the difficulties are between the two bills living together.
Okay, well, first of all, the overly broad definition of a performer is one of the biggest problems in the Performers Protection Bill. So the Performers Bill, before we get to what's bad with the bill, let's have just a quick word about what's good with the bill. The bill actually introduces economic and moral rights for performers for the first time that have not been recognized in statute in the existing act or previously in South Africa. It aligns South Africa with the Beijing Treaty, an international treaty that most players internationally in the audiovisual industry, in the film industry and producers have welcomed. So what does that treaty do? It suggests that there should be some minimum rights, and exclusive rights assigned to performers so that they can exclusively authorize certain acts of commercialization with respect to their recorded performances. It also provides for moral rights. So a performer can actually object to any distortion or mutilation of they say distortion or mutilation, sounds horrible, doesn't it? Or amendment of adjustment of a performance, a recorded performance in a way that affects their reputation negatively. And they can also call upon, let's say, a broadcaster to recognize them in the work. Let's say you're not included in the credits as a basic example. So these rights are very important, and they are included in the Performers Bill, and government should be applauded for doing so.
Wait, before you go there are other rights that are excluded, though. Let's talk about that before we go further. I don't want us to gloss over it. There are rights that are included, and there are rights that other people are contesting. So, for instance, if the use is for educational purposes and so on.
Okay, so that's in a separate bill. So that's in the copyright bill. What I just spoke about is the Performance Protection Bill, and maybe we should just take a step back to underline this point. Mm-hmm. The Copyright Bill and the Performance Protection Bill are two completely different things. Mm-hmm. They are two completely different animals relating to two distinct different fields. In a very basic way, to describe this to you, the Copyright Bill assigns exclusive rights of commercialization to the owner of a copyright-protected work. In the film industry, the owner of a film would be typically a producer or maybe a film studio. The Performance Protection Act actually gives protections and exclusive rights to the performers, not with respect to the film, but their performance that is recorded in that film. So in a way, these rights can come into conflict, and the way that the current Performers Bill is drafted, one of the major issues with it is it places those rights in direct conflict. Mm. And I'll explain that to you in a moment. But so just when you think of the Copyright Bill and the Performers Bill, they are two completely different acts. However, they are intrinsically and importantly linked. How? Because the bill introduces these royalty provisions. They're not only for performers, they also introduce royalty provisions in a different section, Section 6A, for the authors of literary and musical works. So the authors of scripts, for instance, would, in a film industry, and people who write music would also be able to receive royalties from the commercialization of those works. Then there's another clause altogether that deals with the royalties that are introduced on behalf of performers in audiovisual fixations, basically in films and movies and adverts and so forth. Mm-hmm. And it says specifically in that clause in the Copyright Bill that you've got to read that provision of royalties together with the royalty provisions in the Performers Protection Amendment mm-hmm. Bill. And that's where the problem comes into, because the royalty right that government seeks to impose upon the film industry without any consultation with the film industry or with actors or with producers as to whether Sorry, Adrian is disputing that, but let's get back to that in a moment. Let's just say without broad consultation with all of the groups, locally and internationally, and with investors, to say, guys, what business model would work for us in South Africa? Because let's face it, royalties is just one possible solution, but is it the best solution? If you look at the more developed film, audiovisual sectors and film and entertainment industries globally, the USA doesn't have an enforced royalty system. They've got a completely different and quite an interesting system of where they've got a very strong actors guild and serving like a trade union that actually engages on behalf of actors and performers and then negotiates standard terms and so forth with production companies and with film studios. So if performers wanted to have something change, they don't have to go back to, they don't actually have to approach the legislature. Because if you guys think that it's a good idea to actually set statutory terms now for minimum contract terms and for royalty terms, just think about it. If you want to, if you've got no flexibility to amend that through negotiation and actually you know, within industry itself. We do need in South Africa more of an engagement in industry, stronger union representing actors, and also so we can get to a point of collective bargaining.
Stephen, I'm going to ask you to hold, because I see actors thinking now, you see, this is a lawyer speaking, and this guy doesn't get it. You don't get it, you don't get it. What engagement? How has that engagement served the actor so far? I mean, who cares about whether the industry is going to do well or not, because the industry has not looked after its most basic asset, which is the performer. So all good and well to look after the industry. Who's the industry? And how is the industry benefiting? Of course the industry benefits from exploitation of this particular performer. Yes. Can we take a break? I know we're getting all heated. Can we take a break? And then we'll get some water. We'll be back after this. We're back, and we're still with our live broadcast, which is a special broadcast today because we are looking at two bills. We are looking at informing ourselves and educating ourselves a little bit more about the Performance Protection Amendment Bill and the Copyright Bill. And before we went to the break, we were talking to Stephen Hollis, who was talking to us about why is it important for us to sit here and discuss bills that are going to talk to us about royalties? For goodness sake, let's get on with it. Artists, engage with industry players, and let's find more sophisticated ways to do that. So, Adrian, tell me why that's not quite...
Sorry, can I just close?
Yes, of course.
Sorry, I just want to close that point and clarify before I hand over to Adrian here to speak on behalf of industry. Yes. So basically, guys, with respect to the royalties, what I was trying to say is that's only one kind of a model one can look at. And it could possibly work, but you have to refine it in the legislation. So currently, when the Copyright Act now says, yes, you have to pay royalties to performers on audiovisual works, right? That sounds good for the performer, right? But who is that performer? And if we look at the performance bill, like the Copyright Act says you must, or the Copyright Bill says you must do. So first of all, it says, okay, great, royalties for performers. That sounds great. Let's read the performance bill. Who are the performers? that definition is so broad and undefined that it could be anyone. It could be a dancer, it could be... But hang on a sec, you cannot fix something. You have to fix that now.
Yes, that's why we're here.
So
that's exactly why we're educating ourselves, so that we can fix it.
So one of the important points, and I'm glad we all agree on it, is that the Performance Bill needs to be amended in that sense, because otherwise you lose sight of the fact that there's so many different jobs within the audiovisual industry, and even an actor that is in an advertisement needs a different kind of contract and remuneration than an actor that's on a TV series, and vis-a-vis someone on a feature film, an international co-production.
I want to go back to the SABC as well, because we're speaking a little bit about, Adrian will go back to, but we're speaking a bit about the royalties here. And this is where the SABC's got itself in some muddy waters, because you say you're not collectors, but in actual fact you own material and you sell it on, correct? And you earn from that. But you still say you're not collectors. You've collected because you've sold on and you've earned, and yet you still want to recuse yourself from taking the responsibility of the fact that you've earned because you own the rights to that material.
Can I answer that before Adrian answers Stephen? I think we must make a separation between monies received from a sale and the monies being distributed accordingly. The monies being distributed accordingly, yeah, we are delayed in distributing those monies accordingly. We require a whole range of mechanisms in place for us to do that.
Oh no, we can't hear Renee anymore.
They're still recording me, it's fine.
Okay.
So despite the fact that if an actor, if we want to say we are professionalizing the industry, most actors that come to us to get royalties or repeat fees, that come all sorted in terms of paperwork, in terms of contracts,
let's talk about how
comes
complex,
from Saga.
Let's talk about, and maybe Adrian, now you can step in. Let's talk about the complexity of that submitting whatever it is that you need to submit for you guys to claim. How complex is that, Sal?
But wait, I think we just... If we take it from what Stephen is saying, yeah? Because now we just moving
No, but
ahead.
you brought the point up. You said it's complex.
Yes.
We've got 2 hours, and I'm saying let's discuss that. Let's discuss the details of what makes it so complex for us to pay people what is their worth.
If I may step in at this point, and being an actor, I'm going to assume the role of a lawyer now. And my learned friend here, I think, is being a little disingenuous by referring to, yes, Stephen, by referring to the American scenario, which is quite different, as he well knows, to here. We are, and it is a bit of a pie-in-the-sky pipe dream to think that we are in any position to negotiate with broadcasters as actors. And I'll tell you why. Actors' status in law is very undefined. We are certainly not recognized by the Department of Labor. We are considered to be independent contractors. And in fact, if we do try and engage in any kind of collective bargaining to set minimum standards amongst ourselves and industry partners, we are immediately subjected to the Competitions Act. The Competitions Commission will accuse us, as they have done, of collusion. So essentially, that means that as actors, we are being pitted against each other. We are each independent contractors, and we are being treated as essentially competing with each other for the same jobs. Therefore, we may not discuss any kind of minimum standards, and certainly no collective bargaining. So when it comes to negotiating with the stronger parties, like the producers, we have absolutely no power.
What about coming to the SABC? Renee says you can come, have your paperwork ready.
Yes,
and
I'm on my way.
Yeah?
No, but I think we're dealing with two separate issues here. I'm addressing the complexity of
submitting a claim.
Submitting a claim, firstly, and it comes out of what Stephen was saying, and also linked to what Adrian is saying. Under the amendment bill, the Performers Amendment Bill, performers is very broad. There's no definition on a performer,
yes, there
which
is.
in effect means anybody can be a performer. So anybody can claim. Some of the actors here already say that the amount of money they get is very little. Because when you're an actor and you're in a drama series, if I've got 8 principal cast members in a drama series and I get 5 rand, 5 rand must be split equally amongst them. The more they are, the less they're going to get. So in the proposal that was made, one of the SABC submission into the DTI was to say, and if you read all the submissions, whether they came from industry bodies or lawyers, it was to say, let us be specific as to what we mean by performer and in what context is performer, because it will imagine every last person that just appeared on a cinematographic.
So let's give you some
this
credit.
Is a little bit of a red herring.
You know, Adrian, let's give the SABC some credit. They've paid some people. Do we know how many they've paid? Hang on. Do we know how many
They are
they've paid?
player and referee in this game, and this is why we need
does the
a collecting
SABC have an
society.
audit of?
We do need.
Does the SABC know how much is paid out and how much still needs to be paid?
Yes, we know how much is paid out.
Can you give us those numbers?
I'm not here, but I can submit it.
But in ratio
terms,
just sort of a ratio, percentages.
In terms of what?
How much is still owed to artists? How many, in ratio terms, are we still owing? What's your backlog?
So if you look at, if we're taking a net of what we received in terms of what we've sold. Last year, our net revenue in terms of what we sold was 20 million in total. Against the 1.7 billion rand that we spent in the industry, we made 20 million selling. I think we've probably paid out about 9 million of that 20 last year based on the claims. There is a holdback on claims for Encore. And I think we know what the issues are with that.
That I think is not quite answering the question, in the sense that the ratio of how much you're owing people is not based on how much you were what profit you made last year and so on. It is based on the calculation that you already spoke to us about earlier around how much of the production percentages should be going to a specific artist.
No, but that's what I'm saying. No, don't be disingenuous. I said to you,
that's my word.
We sold for 20 million.
No, but I'm saying that was last year.
No, yes, because we do it annually. So this year, I'm still in this year's cycle. So listen, last year, I sold 20 million.
Yes.
I am supposed to hand over 10%, 15%, and 2%.
But you're
that
not
is
owing
27.
Last year only.
No, but that's my calculation is on last year. So if you want to get details further than that, I would have to go into my records and provide the exact same records that I provided to Saga. When did we give it to you? I've got the record, so I will provide, because I don't think I must go into.
But there are artists here who it means everything to.
Yes.
So don't want to go to a records means you, doctor. I don't want to go into your file because it's actually a little bit inconvenient. Does anybody want to respond? Let's take the mic and we'll pass it around. Let's take a quick break and we'll be back. We'll be back after this. Our live broadcast today is coming from Radio Parks Auditorium, and we have a special today. We're discussing the Performance Protection Amendment Bill that's sitting on the President's desk, as well as the Copyright Bill, unpacking all of that so that we're all better informed. And I've got a panel here full of experts. The SABC is also here, and other stakeholders. I'm going to go now to, before I'm going to send the mic around, and I'm going to ask you to please introduce yourselves when you take the mic. But I do see you, Andre Gallo, who are from PMA. You want to comment on the discussion before we went to the break?
Yeah, I mean, from our perspective, just to give you guys a little bit of background,
yes.
The Personal Managers Association is a body of agents who have been working towards, since the early 80s pretty much, towards standardizing and setting ethical and best business practices within the industry, mostly on which we ourselves operate, and then also for the artists that we represent. And we're very much for the bills to go ahead. I mean, as an agent, there's nothing more heartbreaking than switching on your computer in the morning and seeing 100+ hungry faces there, whose faces are on TV just right around the corner, but you know that their families are starving. So from our perspective, we're very much for the bills to be signed.
I'm going to take the mic around, as I said. Yes. Yes, sir.
Hi, Pamela.
Hello.
I'm Advocate Mputle.
Yes.
So I practice as an advocate, and I'm also a talent manager. So I understand the legal jargon that's been thrown around there. But I think the thing that's being missed here is the daily lived reality of the talent, right? And so to the SABC, I'd like to pose the question. You speak about the complexity involved. Is the same red tape surrounding the producers? So when a producer has to get their residuals and things like that, do they go through the same red tape?
Shem, the producers don't get money. They're like actors. Yes, Renee, go ahead and answer.
Can I just come in there
Yes.
Before
Chris, let's just, for those to recap, Chris Mamatuncha, who is from Black Lawyers Association, yes?
That's correct, thanks. I think that we need to come back and talk about the bills. I think that will help us, will help everybody. Because if you look into what is proposed in the bill, it seeks to redress all these complaints, the squabblings that we're having about. I mean, we all know that there's been a lot of wrongs in the past in terms of how performers are treated. And I thought that the absorption that we must have with ourselves here is about the bills and what they seek to bring.
Let me ask you this,
if you look into
how much here of the actors understand the bill? And how many commented on the bill?
You see, I think that there's a need to workshop each other about these things. Because if you look into, for example, Section 6 of the bill, of the Performance Protection Amendment Bill, the proposals there, it seeks to now give government more power. Government is even going to prescribe the kind of contracts that are going to be entered into by various broadcasts. So you will not have an SABC kind of a situation. You will not have a multi-choice arrangement. There will be uniformity in terms of how performers are dealt with in terms of the law. So government is stepping in to say, no, wait a bit. We have witnessed this exploitation for quite a long time. Now we want uniformity across the board. The suggestion, for example, of what is called one collecting society.
Yes.
So the SABC will not come with these arguments.
Yes.
Because there will be one collecting society which must be registered with the CIPC in Pretoria.
Yes, and if you don't report that, then you are against the law.
So I think that there must be a more celebration in terms of what the intentions of government are, in terms of the exploitation of these rights by various stakeholders in the industry.
Why do you think, Chris, there's so much pushback? Is it lack of understanding?
There is. Partly you can attribute it to lack of understanding, but I was arguing with someone 2 days ago to say producers are not going to give up easily because we know what constitutes a copyright. So if I funded this thing and the law says I own it, now this law that is being proposed now, it says
you must pay it forward. You must pay it forward.
It says we must share.
And it's not going to be easy.
So it's not going to be easy because now you are redefining copyright in a way.
Stephen, you want to come in there?
So that's the challenge and the pushback that you see.
And that maybe just to labor the point, when people talk about how artists are divided, is because the term artist is so broad, right? So if an artist is a music producer, for argument's sakes, and is still popular but is a music producer, they have no intention of lobbying for this performers amendment bill because it doesn't serve their interests.
Look, the issue for performers is that, they want the royalties and the repeat payments, and they're waiting for it. But like the people in this room indicated, there's not actually anyone who studied the Act and who actually understands what it will do to the environment. The second question,
let's talk about that.
The second question that we need to ask is, does it stimulate environment? Does it actually stimulate investment into the film industry? Or may it actually, what do the investors say? What do the people say who's actually investing in the production? Let's start with the first question you're posing,
Stephen. What will it do?
Well, I think it would lead to major disinvestment into the film industry. It would actually, in a worst-case scenario, lead to the total collapse of our local film sector.
Wow.
And I'll tell you why. Let me tell you why. The thing is, you remember at the beginning when I said one of the positives of the bill? For once, maybe I should have led with the negatives, like the lawyers usually do. But for once I led with the positives, and now I'm paying for it. The thing is, the positive that I mentioned was that it introduces these economic rights for performers, right? But a negative is, it says after 25 years, so the rights, those rights are the right to exclusively reproduce the performance, which means reproduce the film, distribute the film, stream the film online, sell the film, lease the film, communicate the film to the public. That's the producer's rights, or the film company's rights. The film studio owns the film. But now the performance bill says the performer, and when I say the performer, each and every extra that walked on set, each and every, because performer says every actor, not just the featured performer. That's why we said before that the definition needs to be critically reworded. So hang on a sec, before we get to the definition, and Adrian, don't worry, I'm going to give you a chance after me.
Oh,
let me just complete this point.
Stir up all the dust.
And the thing is, the fact of the matter is that every single person who falls within the definition of a performer will, after 25 years, have the exclusive right to commercialize that film, which conflicts directly with the rights of the producers and the film studios. This means that after 25 years, every single film that's going to be shot when this bill is introduced might actually become unusable.
Hang on a minute, hang on, Chris. I don't really understand that way. That's not how I read it. Does that right not go back to the performer after 25 years? Isn't that just the problem?
That's
that you don't
saying.
like
that's
that?
The problem.
No, it's not a problem.
If every single extra and every single performer on a film,
this is what we're hearing all the time.
Why is that a problem?
Right, because if the film studio cannot reach an agreement,
yes,
before that 25 years is up,
it's a lie.
To actually get their permission to continue with the reproduction, the distribution of the film,
I definitely want
they
the
would not be able to do that.
Which
Otherwise,
is a great thing.
In
fact, I think it's a fantastic thing
while
for
the mic
people.
is going around, could I just respond to this quickly? You're a lawyer. You should know that the legislation needs to be couched in such a way that it is as broad as possible in order to future-proof it, for one reason. No? You don't know that? Well, I think you should go back to your textbooks and just
Adrian,
have a look at that.
While we talk about inclusivity, it's 2 o'clock. We've got to go to the news, and then when we come back, we'll go back
and there are regulations
to unpack that. I promise you we'll come back. We've got an entire hour to argue. 2 o'clock now. Let's go to the very latest in news. We're back with a special broadcast here, and we are discussing the Performance Amendment Bill, and we're also discussing the Copyright Bill. I've got actors, I've got stakeholders, I've got lawmakers, or those who understand the law a little bit better than you and I, and I've got lawyers as well. So before we went to the ad break, we were discussing a piece of the legislation, not the legislation, the bill, and I'm trying to see which section this is now, but where there is limitation of 25 years, for instance, and I had asked you, Chris, to just clarify it for us, because after 25 years, you've got to send it back and get, essentially, the people who were involved initially to give you permission to continue exploiting the product, correct? How's that a bad thing?
The reality of the situation is that the royalty regime is part of what we will call us as practitioners ourselves, we'll call it estate.
You know what, Chris? Let's make it simple for people. So Shaka Zulu, ne?
Yes.
Is older than 25, right? Shaka Zulu, the movie that we know.
That's correct.
Which had big superstars in South African terms, in fact, internationally. And most of them were South African, right? Compare that to Star Wars, for argument's sake, right? In the US. Tell me practically the differences and how this disempowers the locals and the other has empowered the internationals.
So the disempowerment comes in this fashion. Because after 25 years of exploiting the product here, the film here in South Africa, you might find international attraction of that product.
In other words, maybe you could now, there is Netflix. You can now take the very same Shaka Zulu, which we all know is popular.
Yes.
And we can now negotiate new contracts as the owner of the product.
There could be new platforms, as you see now.
Meaning the producer, right?
Yes.
The producer takes that Shaka Zulu movie and sells it to Netflix. That means all the actors there don't have to have a say, as we sit right now.
As we see it.
And they won't benefit.
And that is an issue that, personally, I will urge the performers, the actors, to really make inputs on this issue, because the issue here is about commercial exploitation in perpetuity. So 25 years later, you still want your generation or your work to benefit your estate. You might not be there. It might not be 25 years. You might not be here in 10 years' time. But your work must benefit someone, must benefit your family, must benefit those who depended on you.
Yeah,
because this was your IP, this was your work. So I think that there must be some rearrangement of this clause in terms of what rights it accords to the performers.
Obribo, you're an actor. You see there's a divided panel here.
Yes.
Tell me about what this means to you.
Well, thank you, Pamela, and thank you to the panel. Thanks for giving us, as actors, the opportunity to talk, because I think a whole lot of legal heads have been talking. Stephen, I think let's narrow down the definition of performer. That's very key, so that it's not all and sundry. We can't talk about an extra having the rights 25 years later to explore. Narrow it down. SABC does that. They say leads within the production can claim royalties and so forth. Right? Let's narrow it down so that we don't block this bill just because there's a broad definition. Secondly, if any industry is built on exploitative conditions of its workers, perhaps it should collapse and we should start afresh, right? Chris, thank you so much for mentioning that the government is stepping in and wanting to have more of a say. All we're crying for as performers is a visible and clear-cut regulatory framework. Our sister industries in America, for example, different as the lay of the land might be compared to ours. You've got the East Coast, which is largely Broadway, and then you've got Hollywood on the West Coast. You've got Actors Equity operating with very clear guidelines. On the West Coast in Hollywood, you've got SAG, right? Now, you've got the Screen Actors Guild. Now, that gives us a clear guideline, not only about exploiting rights and future remuneration. It goes down to the point of saying an entry-level performer will not earn anything less than X. Now, what's sad about this entire furore is that it started off with one actress basically writing to the minister and saying, oh, this is what was negotiated. That might have been a private conversation that just made its way into the public domain. At the heart of it is that Usis Vatiswa will be left after the dust has settled and the sensational euphoria of it has settled. What will happen is that producers will lock out Vatiswa and anybody else who's spoken out against producers, who's spoken out against a lack of regulation within our sector. That's all we're asking for. Can we speed up whatever is holding the president back? Can it be signed? Let's sign what works for us for now, at least.
All right, Stephen, I'm going to ask to take a break because we need to pay our bills. Let's do that, and we'll be back with more of your comments on the floor. We're back with our live broadcast, and the broadcast is coming to you live from an auditorium here at Radio Park, and it's a special broadcast where we're looking into the Performance Protection Amendment Bill and the Copyright Bill. We had our mic at Obripo just before we went to an ad break, and I want to just circulate the mic again as well. Tato, you want to add your voice to this? You're also an actor.
Thank you very much, Pamela. Thank you to the panelists. I think this has also been a very informative session, also hearing it also from the legal side, because a lot of times I don't think we really do get granted the opportunity holistically, right, as performers, because there's also theatre actors that also must be part of this conversation. So you're finding that, I mean, South Africa is a big country, right? It's going to be hard to reach everybody at the same time, but yet the industry runs from Johannesburg, Cape Town, and now at least now Durban. So I think maybe the conversation needs to start from the system. We need to understand in this system who are our stakeholders, right? We find that there's the DTI. Now when you talk broadcasting, then there's the Department of Telecommunications, which we're not finding also in this conversation. I'm just maybe asking that maybe let's also grant them an opportunity to have a word in right now, because of now when you talk fiber, all these digital networks that are coming into play, who's making the laws that I generally don't know. So I'm just trying to understand as to who and what is happening, right? Now, 5-6 years ago, you know, there was a big thing that we had here with the SABC. I think a very interesting and very informing piece where 16 actors decided that we're going to walk out of set because of there is no one who wants to actually listen. So at some point in time, somebody must action, right? At the loss of obviously income, at the loss of a lot of other buy-ins, which I think Aubrey was speaking to, where you will be victimized, and that's a reality, right? So before Tato is then an actor, now I find myself now running 3 businesses, having to be a father, also because I want my kids to go to a good school. I want to be able to go to a bank and say, hey, I would like to purchase a house. But banks will not recognize a freelance actor or an independent contractor because of what guarantees are you going to give us that you are going to be able to pay us our 20-year bond, because of, it's a business. Right? Yet we then find in the conversation with the broadcaster, because of, this letter is not a new conversation. It's been happening since the days of Bongwejeng till to now. This is like 40 years, 50 years later. Are we still saying, and this is just my question, we do not know what the issues are? Because I disagree with the fact that we don't know what the issues are. There's been so many creative industries conversations, talks in Dabas. The ministers have been there. We've spoken to the Minister of Arts and Culture. We've spoken to the Minister of Communications. We've said these are the issues. We've had Saga come in and say, here's a position that we take, right? We've also now have a new model that is representing the creative sector from the Department of Arts and Culture called SAfms. Now, when you go to the Department of Arts and Culture, they tell you, no, go back, go talk to SAfms. If you're not a member of SAfms, then there's also Saga. Now, we're finding ourselves in a whole lot of other different conversations where we're not finding at least one source of information streamline. So, it's I just want to throw in that, but then I will come back to the system of who stands to benefit. Because I would like to say, let's follow the money. The ones that are benefiting definitely will have to also have a say here.
Doctor, is there a reason why actors and performers are confused about whose bill this is and who actually should be at the table right now?
Yeah, I'll introduce myself. It's Dr. Putikhasu, actor, producer, writer, amongst other things. I won't mention others on this forum. I do too many things that I get more revenue from besides this. What pains me the most is that I was one of those kids then, which means that I've been on TV for, good Lord, more than 35 years, something years old. I've never gotten a single rand. I'm on TV at least 4 times a day. And I see myself and they're like, Joe, I want to go TV. I was on TV when it was still black and white. I'm still on TV even today, and I look and I'm like, okay, that's the other program. I'm on with my late mother, and then I look and I say, okay, where have we come and how far? If you come through, and I've made many phone calls, those contracts of then, you have to knock on doors. Some of the producers then are not even alive anymore. Some of the commissioning editors, they are on Sasa or Amakroko ancestors now. So now, how do we go back to the kind of contracts that were there? What kind of contract do you have from so many years ago that you produced when you were earning? I mean, when I was starting on TV, my parents were very excited. I think per call I got 70 rands. And for my first movie, I got about 800 rands before anything else. They were very excited. They slaughtered a goat. This is many, many years ago. But what I'm simply saying is, when I watch on TV every single day, I'm thinking, okay, as a producer, I take the risk for business. But I think the main thing that was missed out on here was to have proper dialogue with the broadcasters, more than the producers, because you incur risk as a company. And also as a writer, there's a lot of things of mine that are still on air that also on that I've never gotten royalties for. And as I'm saying to you, on a single day, I'm on TV every single day, I'm on radio, and I still have not gotten that money. And as I've said, I've had to say, okay, now I need to do 1 + 1. Should I still continue? Should I still fight forward? Should I still be happy when somebody says, oh, you are that lady from this thing, I used to watch you on TV, and then I'm thinking, okay, and what does TV do for me? Really, I would, maybe I should take knitting, what is that, needlework classes, so that I can release my mind from the madness. Because I simply think that if we regulate and go back to the core and conversation with not only one broadcaster, who's the SABC, who's come on part because it's also government, but we go to the core of broadcasters, the engagement with what? The producers who are in business, the actors, the writers, and also going back to saying, if they say to you that what is a principal actor, if there's a series and there's 13 episodes, and then I'm in 10 and my role in it, maybe I've gotten how many calls? How do we define what a principal actor is and what a call actor is? Because these are some of the things that people are saddened about. How do you define yourself being over and over on TV, all over Africa, all over for years and years, and people are excited about you and they don't understand, and they say, okay, simple basic things that I think government should just have forums. I know that there is the Creative Workers Union and all of that. Just basic things, funeral policies, what kind of partnerships can happen there, medical aid. Just basic things like he was saying earlier, going to banks and saying, okay, how do you treat this so that this person can also own a property? Because if they're earning, obviously some actors, more than 5,000 rands a month, they do not qualify for an RDP house. So we need to have a conversation where we've got a lot more equilibrium. We need to have a conversation where you are not watching yourself on TV and thinking, you know what, yeah, let me go and make Acha on the road or do other things.
Fumani, do you want to make Acha on the road?
I would rather do that.
Let's just get the mic to Fumani there, because I think that's, you know, there is such a, I don't know if you can see this, but actors are tired. And I think with all the sophistication that people bring to the conversation, I think it's important for us to recognize that, you know, you have people who are actually now disillusioned. And when we discuss a dying industry, because we you know, actors are asking for royalties, Aubrey said maybe the industry needs to collapse. Fumani?
Thanks, Pamela, and thanks for the panelists. Well, for me is that my name is Fumani Anishilabana. I'm also an actor. And like what Tato was saying, I'm at a point now where I've got other business interests, because I found myself 2, 3, 4 years ago becoming bitter because of TV. And there's a lot of repeats of my work on TV, but nothing is showing. I mean, even my agent, we complained a lot with her, and then she said to me, Fumani, there's nothing we can do. So now, here's what I'm hearing, what we're discussing. First and foremost, in South Africa, we pride ourselves with how our policies, how our constitutions, and how our ways of doing things are good. How did we get this? Before 94, we didn't have anything. We had to check other worlds, how they do things, copy that, and adopt, and worked. So no one in the panel here, especially who's doing law, can tell me there's no framework of what we did. Like what Tato was saying, what we've been saying, it's been said, it's been said. So now, we find ourselves discussing what we're discussing here, talking about what-if problems. No. We can't be discussing what-if problems, what will happen. Hence we sign, hence it's a bill, hence it gives way to say, you know what, there's something that we missed there we can rectify. So if we can we will sit here and discuss the what-ifs. We're not signing what is happening now. We'll find ourselves with a lot of actors who are dying, sorry, actually, I'm putting it wrong, who are committing suicide because they're depressed. They see themselves every day on TV. I mean, our work, we know our work is at international standards, where we've got a lady who recently won an Emmy. It simply means our work is good. But if we can find ourselves in a position where we're still discussing the possibilities of a pothole that will definitely come, but not negate what's happening now, we're not going to solve anything.
All right, so let's take this conversation forward, and maybe this is where we need to now get to the practicalities. Okay, so somebody said earlier it's at the last draw, but it's in the president's office. Both bills are sitting in the president's office. What we need to now talk about is where to from now. The bill sits there. The process is the bill can either go back to Parliament, correct? And you and I need to inform perhaps what it is in detail we need to tweak in that bill. Chris, your suggestion, so that people know how they can add their value to this bill.
Excuse me, the likely possibility why the president is not signing the bill.
Yes.
One is that there is no uniformity or there is no unity within the performance or the performing arts. So the president does not know what to do.
Chris, you see here in this room, Chris, yes. In this room,
yes,
everyone agrees here.
Okay.
I'm saying the bill may go back to Parliament. So let's understand this. It may go back to Parliament. It may not go to Parliament.
Yes.
It may be signed as is, right? But it's not being signed. So two things can happen. If we have the president sitting with the bill and it's not being signed, the one question is how, and this is where we need your expertise, gentlemen, not so much your opinion, your expertise. How do we get him to sign it? Because it can't just sit there. In my understanding, it's actually illegal for it to just sit there. It's got to have a lifespan, right?
Okay. Can I...
Yes, Stephen.
Guys, it's important to understand it's an important point that Adrian actually raised before, or mentioned, that the president doesn't have the power that his counterpart in the United States has. Trump, if he doesn't like a bill, he can just say, I don't like this thing, take it back. He doesn't sign it. President Ramaphosa, if a bill is actually approved by Parliament, he has to sign it. unless he has constitutional reservations regarding the bill.
But
now, the thing is, I just
sit.
want to, guys, we've actually not got enough time today to discuss the very important bill that this bill is linked to. Remember, we said at the beginning that the performance bill is intrinsically linked to the copyright bill. Now, if we had another 2 hours, I can explain to you why the president hasn't signed both bills is because the copyright bill suffers from fundamental defects and constitutional issues.
But Stephen, let's stay with us. No.
And now the president has got that bill, so the president cannot, because it's linked to that defective bill.
Work with us here. Because of times, you've just said we don't have time. Let's be practical. I'm saying the issue of the detail of what's wrong is not the point here. It can't just sit, right? We need to move it from the desk or the drawer to move. It either needs to be signed or sent back. How do we get that to happen?
I can say that. There is a legal solution to potentially uncouple the performance bill from the copyright amendment bill. The copyright amendment bill requires fundamental additional work, and I personally have no doubt that the president will refer that bill back. But there is a way to uncouple the bill by removing some of those overlapping provisions and then with minor revision in Parliament, get the performance bill passed quite quickly and swiftly.
The issue, I just want to jump in, the issue with uncoupling is that there are key provisions that are related to performance protection amendment bill that are entrenched in copyright. So the Copyright Tribunal, for example, so for performers to actually approach any sort of tribunal to actually enforce, collective management organizations to pay them. That's all in the Copyright Act.
But guys, we've missed the point.
For the actors to form collective management organizations, that's all entrenched in the Copyright Act. And I don't know if it's possible at this stage to uncouple, delink. It's on the president's desk.
Guys, we are again getting very sidetracked. Let's be simple about this. We are saying, whatever the issues are, the president does not make law. Does everybody understand that? He's not Parliament. The issues you're addressing now, we can talk to with Parliament. Right now, on his desk, we can't do anything about it. I'm asking, how do we get the bill either back in Parliament where we can deal with the issues, or we make sure that it doesn't sit on the desk forever? Yes, Chris.
If in legislation making,
yes,
if there's something called public consultation,
yes,
and if you see somewhere in the commentary, it talks about the powers that are accorded to provinces, because in the main issues of IP are taking place in the provinces. That's why there's a lot of activities. So it talks about the powers that are afforded to provinces. But my point is the following: is that if we reach a stage where we conclude that there was not enough public consultation on a bill, on a legislative making process, that bill will not stand constitutional muster.
Okay.
And what will happen to that bill? It will be referred back for further public consultations. And the sentiment that I seem to be getting from the stakeholders, from the industry, is that there seems to be a lot of gap that is not closed in terms of the issues that the stakeholders want to see encapsulated in that particular bill. And my advice will be that it is important that there must, one, be unity within the performing arts sector. Secondly, if there are issues that they feel that the president must consider before assenting or signing that bill, they must make an effort. And one of the legal avenues available is to also, for example, approach the Constitutional Court.
Okay, so that's an option that I think we want to now go to, because I think we're now moving somewhere. It is now 1:30 and I want us to take the headlines before we continue. But I also want to tell you that we're streaming live on Facebook, so all of you, if you've been like poking your noses or whatever, I'm sorry I didn't tell you in advance. And actors and their egos, now they want to put on lipstick. So we are streaming live, and we'll continue this the special broadcast until 3 o'clock. It's now 1:30. Let's go to the headlines. So we continue our special broadcast, and we're coming to you live from the auditorium at Radio Park. We're discussing all kinds of things, but really central to this discussion is Performance Protection Amendment Bill and the Copyright Bill. And we've moved forward. We've now discussed how are we going to now do something about this bill. How are we going to move this bill? How are we going to get it signed? Yeah.
Hello, panel. Hello, panel. I'm going to speak as a young producer and an actor and director as well. I have to say, and I've always been called the Julius Malema of the industry, and I don't know why. But, you know, this whole jargon and this whole legal thing is confusing. I want to go back to what we've been talking about. SABC must decide whether they are collecting agents or not. You know, we can't have them collect and then not collect, because that's what confuses the people. They don't know where they're going to get their money from. And to answer your question as to whether this is going to be signed by the president or not, I'll give you an answer.
Tell us.
We are dealing with government and people who do not have an idea of what the industry is like. You are dealing with people who have never seen an actor's contract, what it looks like, and we are expecting to get answers from them. And I'll say this as someone who has gone around, you know, pushing for funding when it came to the NFVF and all of that. And for me, when it says Black Emerging Filmmakers Fund, the emerging word comes out, you know, it stands out for me. And when you get declined because you did not submit a BE certificate, which is just one page. For me, when you say Black Emerging Filmmakers, it says that I am not a bomb production, I am not an Oka Media, I'm not the big productions. It's us having to uplift the actors who want to become producers, or for the script writers who are sitting and want to become producers. You know, we need to show them in how things are going to work, instead of us using the very same system to decline them and without us even having to read the story.
So you've actually just said that we have parliamentarians and lawmakers and government who doesn't understand.
Have no idea what we go through as performers, and that's why we'll always have this back and forth whether what a performer is, and that's why we'll call performer broad, you know, because we're trying to bring corporate into this industry, and then when corporate laws, when they're supposed to apply on our industry, then you get people where we go to banks and then they tell us, but when you are just an independent contractor. So there's a lot of clash that is happening, and that government is failing to fix.
Okay. Notanda, I want you to listen to this, because now we've got calling us on the line Duma Nkosi, who's a chairperson of the portfolio committee that was sitting, putting this bill together. And Dada Duma Nkosi, thank you so much for joining us. Good afternoon.
Hi, how are you?
We are well, thank you. Thanks for calling us.
Yes, I thought I should just actually, as a newcomer in the space, I've just been sworn in May, and I haven't given this important responsibility to be the chairperson of the portfolio committee. And this very important legislation, I found it being actually the process where committee has concluded their work. Now it's at the point of the assent of the presidency. But obviously, I thought one would be able to contribute just by saying, looking at the objectives of the bill, key issues that actually can help us start working on the space, like the speakers that have just spoken by our colleague. It's people who know, feel, and understand what are challenges, and it has not been actually supported legally in any way. And there's been no regulated space. And on our part, we thought this is just one step, but it won't solve all the problems. But for those who actually are participants in the space, we thought it actually gives an opportunity working through those objectives to get the situation corrected. So I think, yes.
I'm so sorry, I'm not going to let you go, because I think there are a lot of people who want to ask you questions. So it's very nice you're here, but I want you to stay. And Notando, you probably have one or two things to ask him. Go ahead. No. So, can we get your mic on?
It's on.
Yes,
and I'm
go
saying,
ahead.
Papa, have you, with all due respect, I'm asking, have you ever seen an actor's contract?
Well, basically, from where I come from and the understanding of the space, I would say I'm not that experienced or that informed to actually engage at the point where I would say I understand and know what are real issues in the sector.
Notando?
Just to jump in there.
Just introduce yourself, Notando.
Notando, it's Notando from the organization Recreate. I think what's very important for everyone to understand in these conversations is contractual issues versus legislative issues. I mean, you asked Pamela earlier when we first began these discussions, why is this a DTI bill, not a DAC bill? Because these bills are looking at issues of intellectual property, which is why they are sitting with the DTI and not the DSAC. And I think it's important when we're discussing these bills to also take that into consideration, that they're dealing with issues of IP and how to regulate and shape laws around IP. And yes, there may be a plethora of other contractual issues which performers are experiencing, as you know, came forth in SAfms letters, but those are not issues of IP, and therefore they're not addressed in the bills because they have nothing to do with intellectual property in certain respects.
Go ahead, Doctor.
Again,
Doctor, introduce yourself.
Dr. Putikhaso again.
Yes.
I think one thing that would help a lot is if our president, on one day, as he said to Mamina, can maybe come one day on set to have that experience, or in a radio recording. I know because of he was involved as a unionist before in mines, to know and be on site and to see what happens on a set practically, just to absorb everything. I don't promise I can give him a small part. Maybe I'll write him a small part. I'll try, but he must practice very hard. And you too, that I'll give you a small part for now, so that you understand what it means and the value that people put and the investment that people put, so that you understand that some of the actors are very basic people who might not be able to sit here and understand that kind of bill. It needs to be broken down a little bit more to a language that they can comprehend and understand also. Thank you.
Tato.
Sure. Dumelang Tate, ke Thato Molamu. I guess for me, if we are addressing moral rights, right, then I guess also when you talk even of IP issues, it stems on the right issue, So if ever I'm going to give a performance, I expect that my performance has a sense of IP because I also bring my creative ability from the 3 to 4, 5 years that I've also now gone to school, got my PhD and all of that. So the conversation now maybe also as a question is, the stakeholders that have come to you, who are us? Because we're talking now labor, we're talking telecommunications, we're talking DAC, we're talking DTI. Who have you been consulting to be able now to give a particular narrative that maybe might be fitting to the industry? Because I think sitting here, we're just seeing that we have a mammoth task. Because I'm still as very confused. Because I'm just trying to understand where do we even start, right? Because I don't see it, I don't see where now we address it. Because there's also script writers in theater. That's where DAC also comes in. How does that also then get protected, So it's very conflicting conversations, but systematically we know that the contracts are there to benefit a particular system, right? That's why when I would also ask, why were actors getting 2% in the 70s? Right, whereas now producers are getting 15% and directors are also getting 10%. That for me is also it's a mind-boggling. How did we even get to those numbers? Because of economically, and just to be also quite frank, is that we come from a history that black people, right, were impoverished from information. Yet we still are perpetuating the very same thing, where we're now making these bills, we're having these consultations, and yet the layman who also did not have access to a basic university, conversation is going to find this conversation very, very difficult. So maybe what measures are from the parliament, because I think Arisho is quite right. We have to have people that are professionals in the industry to guide the industry, and not to disrespect Juntate, because I think it's also wrong. That we have individuals that have never operated in this industry making decisions about a key industry that can create jobs, national development plan, and we keep complaining, where Nigeria is a $5.1 billion industry in film. In the US, 2-3 years ago, research said it's $46 billion, film alone. So yet we're not having those economic conversations, but it's very confusing. So
Aubrey,
I'd need guidance.
Go ahead, Aubrey. Your voice is important. Aubrey Boer is... yes, go ahead.
Hi, Dumelan Tati. You know, often what the powers that be communicate to us is the need for us to organize and to come together. There are members on our panel who say you need to come together. Our industry is a very broad church, a term that's loosely used in politics often. It's a very broad church. Hence, we need you to come in and say, we are willing to help you. We are willing to help and walk hand in hand with you to create for yourselves a regulatory framework that we can draft into law so that it's enforceable to the SABC, to multi-choice, and. We've got to expedite the process of signing or amending this bill where need be. We speak of the problems about decoupling. All of that is all good and well, and it's all good jargon, and it sounds lovely to pontificate about these things. But the lived experience of us as performers on a daily basis is that we are sitting here ungoverned because there is no regulation that says this is how you'll be treated, this is what your pay scale should be. With 20 years in the industry, I mean, we're sitting with very experienced individuals. Jamie Bartlett over here is sitting, he holds a degree. I don't know if you even hold a master's, I don't know. He sits with a qualification and he's in the industry for over 20 years. And still, he has to fight. He has to fight because there's no regulatory framework that says this is how much you should be paid. So please, let's expedite whatever needs to happen so that we can be protected. Thank you.
I'm going to ask, yes, go ahead, Fumani.
Hello, Ntate Thobela, you're speaking to Fumani and Shilobana. You see, what the two actors have said, it's not something new. I'll give you a quick brief. The importance of people who are in the industry dealing with these issues. 2002, I was at the State Theatre. That's where I trained. And there was these things, Imbizos, that every ministerial department used to do. At the State Theatre at the time, Dr. Paulo Jordan came to do that certain Imbizo. Now, I was 21. I was still training then. The question that I asked myself whilst he was speaking, I said, but how can a man who knows nothing what he's talking about come and address us? I was 21 then. I'm now 40. I'm still asking myself the same question. So you see, the issue is not only about why do we have to do this or this. We just need people, sir, from your part that know what they're talking about. There are a lot of people who are experienced, who know what they're talking about. Some of them are not working actors anymore. They hold degrees, they hold PhDs in this field. So all we're asking for, do not make decisions in a vacuum, because we end of the day, we'll go back and forth with trying to solve problems that we don't know that are there. Thank you.
Stephen Hollis, go ahead.
Ms. Nkosi, welcome to the role. Clearly, you're faced with a tremendous challenge. I've got two quick questions for you. I think I saw a notice somewhere. First question, that during the month of November, the Portfolio Committee might wish to inform itself on IP. I'm wondering if that's so, and if so, if you can give us brief details of that, what that entails. And secondly, I want to mention, in my experience, I'm one of the lawyers. I'm a partner at Adams & Adams, and I was part of the Institute of Intellectual Property Lawyers team that presented to Parliament during the August 2017 parliamentary hearings, when your predecessor, Ms. Fubs, was the chair of that committee. And what struck us, all of our lawyers, I don't know a single copyright lawyer or a person from industry or from investment perspective that disagree on this point. There was a very clear misunderstanding from the drafters at DTI when they started conceptualizing the bill as to how industry actually works, and that the film industry has different sub-industries, and that the music industry works different to the film industry, and that the publishing industry and the computer programming industries are different and require very specific solutions. There was zero impact assessment studies conducted on how the very critical amendments to the copyright bill that introduces so many ways that users can make access and distribute works, including films, without necessarily paying a license fee to the user. So there was a clear disconnect there, and I'm hopeful that, moving forward, can you tell us is there any initiative in place? Has it been recognized that there needs to be more meaningful engagement with the different sectors? Because this creative industry can invigorate our economy. The president is looking for a way to breathe life into it, and I think you, sir, hold one of the very key positions in our government at the moment. I want to wish you good luck, and I hope to hear from you on this question.
Mr. Nkosi, do you want to respond to that?
Yeah, the most important part is that the building block in terms of the legislation processed by the portfolio, which may not be very close to professional and experienced space, because we are the Portfolio Committee of Trade and Industry. So the level of entry in terms of the engagement will be around arts and culture. And the reality of the situation is that we think a building block in terms of the legislation, particularly speaking to the objectives of the bill, the main issues are covered in a broad way, but the detail will obviously, when it comes to implementation and regulation, may actually have to be processed to a point where we respond to the questions and comments raised by the professional team you have with you there, because those are the people who, day in and day out live what we actually trying just to contribute a bit about. Because the objectives of the bill in the 4 areas of moral and economic rights, rights of performance in terms of agreements, the issue of protection of producers, sound recording, and actually the PMS and copyright management info. So those are things which are actually we see as building blocks, and we're responding broadly at the point of knowing that there are serious challenges on the industry. So on the space where we're coming in, it's not a point of being able to actually resolve, but create a platform where we can build up and respond to the challenges we face in the sector.
Mr. Nkosi, it's rather late because the bill has now moved on. So now that you know that there needs to be more work, you tell us, how do we get the bill back to you?
The reality is that the bill was before the president for assent. At this stage, the president has not actually agreed or signed the bill to continue implementation. So which means at this stage, the bill is not signed by the president.
We know. So we are saying, you can hear that there's a lot of contestation around certain elements of the bill.
True.
And you can hear, and you've admitted, that maybe people sitting in the room are not adequately equipped to have drafted this to the capacity of what is required. We're saying to you, you tell us, how do we get the bill back to you? What muscle do you have to get the president to bring back the bill to you? Or you tell us how on the ground we can force the president to bring the back to you so that you can start consulting us properly?
So I think maybe largely because there were processes.
Yes.
I think in terms of your summary and the point you raised, you say it was insufficient. It didn't cover the real issues that it should. Mm-hmm. And on the basis of that, we think the bill doesn't respond to real challenges faced by the industry. Mm-hmm. So I think that's the summary on my side. And obviously, because it's before the president, having the public broadcaster at this interview, the summary of what comes out and what is it that we may try and inform the president on, because he's having the bill on his hands, might be quite important between ourselves, there's the portfolio committee chair and the broadcaster, having coordinated all those professional individuals in a sense of being able to capture their challenges and see how we can raise them to the president, because that's where the process is at this stage.
Can we hold you to it? You can lobby your politicians. Bring the president to the fore.
Well, I think having actually spoken to process and on the basis of what you're raising, I would really like to have the facilitator of this program to have a summary reflection in terms of what we can raise. We will actually highlight at the committee and then maybe make sure that we facilitate that the President have access to those issues raised.
Does it satisfy everybody? Guys, he's here. We need to wrap it up. So your 2 cents worth. Yes, Adrian, go ahead. You've got the mic.
I would like to just put in a word.
Just say who you are.
My name is Adrian Galley, and I am here on behalf of the members of Saga, who are all performers. None of us extras or ball boys or anything like that. What I would like to ask the panel is, we are very clearly here on behalf of performers, and we're talking about the Performers Protection Amendment Bill. I have colleagues sitting on this panel, one who represents the SABC. I have another person to my left who is a schooled man in the matters of IP. And I'd like to ask him, you're representing somebody here, I take it? You do have a client on behalf of whom you're speaking here?
You mean myself?
No. So, Stankosi, right now, maybe they're just bantering between themselves. They want you to hear this.
Yes. Sorry to interrupt. I'm a partner at Adams & Adams, and we do represent people from the creative industries, yes.
Yeah.
But also performers and also musicians, people at both ends of the industry, not just the rights holders, but also producers and also actors, performers, and musicians.
Which actors are you referring to there?
Adrian, we need to wrap it up. So make the point to Ntatenkosi so that we can wrap it up. Chris, go ahead.
Good afternoon, Comrade Duma. I think my name is Chris Mama Tuncha. I'm an attorney in Johannesburg. I practice, amongst other things, in the areas of entertainment law. My 2-cent input is that from the discussions that we've been having here with the actors and the performers and the producers, is that there's huge reliance and hope that government is doing something about the plight of this particular group of people. And I think that you, as representing government, you must do more. And I think I'm comforted by the fact that you are conceding, you are making concessions that there might have been insufficient consultation. So I think that take these issues up with the powers that be and take care of the plight of performers in our country, because these performers are also our family members, they are also our friends and brothers. They deserve respect and recognition like any other sector in the country. Thank you.
Renee, do you want to just add your word as a SABC?
Yes, hi. The SABC has made submissions.
Just start that again, please, Renee.
The SABC has made submissions as the SABC and as NAB, the National Association of Broadcasters. We were ignored like everybody else by DTI. So we're hoping that we can reconvene. And I would like us not to get distracted by saying that the bill is going to solve the industry problems and just say the bill is there now, we walk away. There are many issues in the industry that's not going to be solved by the bill. There are issues around labor, there are issues around rights, and we really need to address those issues. There's been many organizations set up by various presidents in their offices, various ministers. Nothing's come of them. Government's gone a long way in setting up funds, but they are laying all over the place. There's no concerted effort to pull it together and look at the state of the industry. So I would really like to say, as much as we are going to sign or get to a point of signing this bill, that it's not the end. This is just the start of addressing the massive issues in the industry. Thanks.
Anyone else who wants to have the final cherry before Ntatenkosi goes? I'm sure you've heard, hey, Ntatenkosi. I'm sure you've heard, and I hope that you take the sentiments with you.
Yeah.
Your parting shot, sir.
No, I think let me just agree that in terms of the engagement that you have had, we actually adding to the process of taking ourselves forward on the basis of where we at this stage. We will acknowledge work done, because I wasn't even a committee member then, I've just actually joined, given this very huge responsibility. An important one is that we should acknowledge the work that has been done, and from where we are on the basis of what's before us, which I see as a building block, we should actually be able to see how we add value, because in every legislation that gets passed, there will be the implementation part and regulation part, and there might be lots of space and gaps you can close in terms of, say, copyright and the performance space, because all those issues are interlocked at some way and impact negatively on lives of those who are participants in the space. But for now, if we can agree that some feedback in terms of consultation, taking into account where we're at in terms of the piece of legislation before us, what is it that's possible in terms of actually engaging the committee or raising issues with the president.
So you'll understand that you have a very agitated industry. And I think, and we've also heard this from many stakeholders and many people sitting on your chair. So maybe we want to know, when can we hear from you again?
So I think it may be important that we use the platform where one has just connected and starting to actually understand issues, to be able to be the starting point, because you are able to coordinate all the professional, talented and experienced individuals in this discussion. But the sector might be larger in terms of stakeholders, but in terms of the platform that you have facilitated for today, maybe one would actually have to come back to you as facilitator to say, what is it that might be issues that we can pick up, highlight and actually facilitate in terms of the highest office of the president and the committee, and see what's possible in actually looking at implementation of the bill moving forward.
So you're not in the room. I have to tell you, everybody's shaking their heads because you can't see them. Everybody is not in belief of what you're saying. They're now shaking their heads. Others, you should see the one who's got a paper and she's now blowing her face with this paper.
I'm sorry.
Yeah,
I'm sorry for that.
It's that level.
Don't kill me.
And it's that level of just people feeling like they've been left out in the cold. One said earlier, if you guys don't see how important this is, we'd rather shut the industry down. That's where the industry's at. I hope you recognize that.
Well, with the whole respect, I'm sorry if ever I actually have offended the panel you have before you. But I think I have tried to make sure that I make myself available to actually just phone and say, we are trying to start off where the other parliamentarians committee left off. And we're hoping to find the best way on how we can get the balance right and start engaging on issues which make difference on lives of people in the sector.
Dr. Dumankosi, thank you so much for making yourself available, who's the chairperson of the Portfolio Committee of the Department of Trade and Industry, and the portfolio that was putting these bills together. And I'm afraid we've kind of run out of time. I don't know how you guys feel. Lots of people in this room feel a bit deflated. And I think it's indicative of how, the mood is at the moment. But thank you for coming. Thank you for making the time. And I hope that we will have this conversation again where we take it forward. He said he'll come back to us. Let's hope that does happen. Thanks, everybody. It's almost a minute to 3 o'clock. Maschaba will be joining us with the focal point. But let's do this again next week. And thank you very much for listening. 1 to 3 next week on Monday. Thank you very much, everybody. Thank you very much. It's 3 o'clock.